Hello all. So today is going to be our second session, and in today's session we are going to cover very important act, which is Transfer of Property Act 1882. In session number 1 we had covered Land Acquisition Act theory, concepts and case study also. So today's session is also very important from examination perspective as well as from valuation perspective. This act is like Land Acquisition Act is very lengthy act. However, we'll try to cover all major aspects, major and important sections which are relevant for examination perspective. In today's session we'll try to cover entire act into one session. It is going to be little bit lengthy session today. So this is the complete syllabus, out of which Land Acquisition Act portion we have already covered in session number 1. In today's session we'll cover this entire property act, property TP act, and in upcoming 2 to 3 sessions we'll try to cover rent control, right of way, saving feature of RERA, and then inheritance and succession acts. So the act came into force with effect from 1st July 1882 and applies for both immovable and movable properties. Please remember, this act applies to both movable and immovable property, and also to tangible and intangible properties. This is also important. 1 mark theory question can come out of it. The act has two broad sections, part 1, part 2. Part 1, which is up to section 53A, talks about general principles of Transfer Property Act. However, with effect from section 4054 till section 137, specific type of transactions are being explained in the act. So specific type of transactions could be like sales, mortgage, charge, lease, exchange, gifts and actionable claims. We'll discuss all these things in detail in upcoming slides. So thus the act outlines legal procedure for transferring property. The act is stated for it lays down the procedure for transfer of property, both present and future transactions. Please remember these things, present and future, but between living single people or group people. So living word is very important. The act talks about transfer property between living people only, not non-living. So as per the act, the living person means and includes a company or association or body of individual, whether incorporated or not. 1 mark theory question can come out of this slide. Please note down. Immovable property, object or item which cannot be moved without destroying or altering it. So this is the definition of immovable property as per the Act section number 3. An example of immovable property are land, plant, machinery fixed to land, benefits arise out of the land, things attached to the land. Please note down exception to this movable property are standing timber, growing crop or grass. These are not immovable property. 1 mark theory question may come out of this part or this exception part also. So let us quickly move to the general principles of transfer of property, section 5 to section 53A. So as per section 5, it talks about transfer. Transfer is an act by which a living person conveys property in present or in future to one or more living persons. For example, A to B, C and D. A transfers a property in the name of B, C and D, or to himself. That is, for example, a person can vest property in trust and himself become the whole trustee, or to himself and to one or more other living person. For example, A and B, me and myself, me and somebody else, A to A, B, C, D. These could be different type of scenarios under which transfer could happen as per section 5 of TP Act. What cannot be transferred? So this is explained in section number 6 of TP Act. Spex successionis. It is a Latin word. It means expecting or having a chance of getting property through succession. Spex successionis is therefore not a present property or any right over property. It is merely a possibility of getting certain property in future. So if, for example, I'm likely to get a property from my father, it is expected that my father will give me that property after say 1 year, 2 year, or after death of my father. So till the time this property is not transferred in my name, I cannot transfer it. I cannot transfer my right of getting my property from my father before getting it actually, right? So right to re-entry or power of termination cannot be transferred. Let us try to understand with an example of an example. A conveys property to B provided that land is used for residential purpose. So A has given a property to B subject to condition that B will use that piece of land only for residential purpose. If B uses the land for some other purpose, then A may re-enter the property and take the land back. So in case B use that property for any purpose other than the defined purpose, which is a residential purpose. So A has a right to take back that land from the B. So such a right cannot be transferred. So A cannot sell that right basically in isolation. Easement rights. Easement rights apart from dominant heritage cannot be transferred. So this servient heritage, dominant heritage, we have already discussed in I think playlist number 1. So please go through that part, so you will get clear idea of what is dominant, what is servient. So easement right apart from dominant heritage cannot be transferred. Thus easement right in isolation cannot be sold. Once property is transferred, easement is by default transferred to. So if I have a right of way or right of air or right of water disposal, which is an easement right over over the property of my neighbor, I cannot sell that easement right in isolation. It gets transferred along with the title of transfer of title of my property. As interest in the property which only owner can enjoy personally cannot be transferred. So if I have any specific interest which only as an owner I can enjoy, I cannot transfer. There is a restriction transfer of the interest that also cannot be transferred. A right to future maintenance cannot be transferred. For example, A and B are related. Court orders A to pay maintenance expense to B. Thus B cannot transfer his right for future maintenance. So for example, there is a dispute between husband and wife. Court says that husband will give 1,000 rupees of alimony to the wife. So wife cannot transfer that right of getting 10,000 rupees from his husband in the name of other person. Right to sue. If A commits a wrong against B, thus B has a right to sue A, but B cannot transfer his right to sue A to Mr. C, anybody else. You have done something wrong to me, I have a right to sue you, but I cannot sell that right of me to somebody else to sue you. Public office. If you hold a public office such as judge, inspector, doctor, etc., then you cannot transfer your public office to anyone. Stipends allowed to military and civil pensioners of government and political persons can also not be transferred. Salaries of public officers, whether before or after it has become payable or due. No transfer can be made opposed to nature of interest or to a person legally disqualified to be transferee. Transfer Property Act is not applicable on following: court sale, wills, partition or family settlement, gift of idol, surrender or lease or relinquish. So please note down these 5 bullet points also. 1 mark theory question may come. Out of these 3 slides, you can expect at least 1 question. Who can transfer property? Section 7 talks about this thing. Any person who is competent to contract and authorized to dispose of the property can transfer the property as per section 7 of TP Act. Who is competent person to sign a contract? Any person who is competent to contract, any major person having sound mind and is not disqualified from contracting by any law can sign a contract. Following cannot sign a contract: person of unsound mind and minor. So who is person of unsound mind? A person with unsound mind at the time of signing the agreement or contract is not competent to enter into a contract. The unsoundness may be permanent or temporary. An unsound person is not capable of understanding and family rational judgments. So basically, if I have consumed some wine or liquor and I'm signing a contract after consuming some drugs, alcohol, so I'm not in my conscious, so that a contract is not applicable. A contract signed by a minor doesn't have any value in eyes of law. As per Indian Majority Act, a minor is person who has attained 18 years of age. However, in following cases, a person becomes major on completing the age of 21 years. So one mark theory question may come out of it. Then what is the age of a person to become major? So please note down this thing that as per Indian Majority Act, a minor turns into major after he or she attains an age of 18 years. However, in case of Guardian and Ward Act, and where superintendence of minor property is assumed by court law, so a minor turns into major only after attainment of 21 years of age. So this is confusing question, most likely to come. What if major guidelines are different in two land of laws of two persons signing the contract? For example, in India, age of majority is 18 years. However, in Sri Lanka, age of majority is 21 years. Thus, if a person of 20 years signs the contract, then the following rule shall apply. In case of contracts relating to ordinary mercantile transaction, the age of majority is to be determined by the law of place where the contract has been made. So in case of mercantile transactions, normal trade transactions, the age of the majority will be considered. So if the agreement is being signed in India, then it is okay. But if it is being signed in Sri Lanka, then it is not valid. So in case of contracted into ordinary mercantile transaction, the age of majority is to be determined by law of place where the contract has been signed. So this person can sign a mercantile contract if he is signing that contract in India, not in Sri Lanka. In case of contracts relating to land, the age of majority is to be determined by the law of place where the land is situated. So in case of property, land or building, so if the property, if A and B are signing a contract, right? But the property is falling in Sri Lanka. So this person is minor, so he cannot sign this contract. Whether the contract is being signed in India or in Sri Lanka, since the property falls in Sri Lanka. However, if property falls in India, then contract is valid. Either it is signed in India or in Sri Lanka. No issues. How to transfer? Section 9 talks about this aspect. In case of tangible properties, if property value is less than 100 rupees, such transfer can be done by delivery only, oral transfer. So each and every slide is important. 1 mark theory question can come out of any slide out of this. So if tangible transaction is there, physical property, tangible and intangible we already discussed. In case of tangible property is more than is rupees 100 or above, transfer can happen only by registered instrument. So up to less than 100 rupees of tangible property can be transferred through oral transfer only. There is no requirement of creating any registered document or registered instrument for transferring the property, tangible property. However, if tangible property is of rupees 100 or more, then registered instrument is mandatory as per TP Act section number 9. However, in case of intangible property, transfer can happen only by registered instrument. So even if a single rupee of transaction transfer of intangible property is happening, registered document is required. Attestation. To avoid frauds, it is mandatory to do attestation of registered instruments. By at least 2 persons should be witness. Each witness should see both executants and also sign the registered instrument. It is not mandatory that both witnesses should be present at the same time. They may sign the instrument at different times. Please remember this point. Animum attestandi. This is also a Latin word. Both the witnesses should have an intention to attest the document. So this is also important for having kind of to do attestation of any document. uh, Animus attestandi is required. So witness should be willing. There should not be any coercive action. There should not be any force, or there should not be any they should not be they should be willing to do attestation of the document, and they should be freely willing. Condition restraining alienation, section 10 of TP Act. If transferor prohibits the transferee from further alienation, that is further transfer, by putting a condition or limitation, such condition or limitation is void. Thus, transferor cannot restrain transferee from alienation. For example, A sells his house to B with a condition that B cannot transfer this house to anyone except C. The condition is void because C may be chosen as a person who may never purchase the property. Please, this act is there. So exception is there. Lease is an exception for the above rule. And a deed dedicating property to deity, God Almighty, contained a condition absolutely restraining transfer is valid. So please remember these points. Condition restraining enjoyment, section 11 of TP Act. In case of absolute transfer of interest, that is sale, gift, exchange, if transferor puts a condition on mode of enjoyment of the property, such condition is void. Thus, transferee is not bound by the condition. Let us try to understand with the help of an example. A condition restraining the mode of enjoyment may be made by the transferor, provided it is for beneficial enjoyment of transferor's own adjoining property. So this is a comparative analysis between section 10 and 11, condition restraining alienation and enjoyment. So in case of condition restraining alienation, it refers to a restraint on alienation. This act talks about further transfer, and this talks about enjoyment of the rights of the property. So this is the difference between section number 10 and 11. And this act is applicable to transfer of absolute interest as well as limited or partial interest. So absolute and limited. It applies to transfer of only absolute interest. So enjoyment, this section 11 talks about only absolute interest. Transfer for benefit of unborn person, section 13 of TP Act. Transfer of property cannot be made directly in favor of unborn person. A person who is not yet born, any property in his name cannot be transferred. The Act says that the property can only be transferred to a living person. Thus, to transfer a property to an unborn child, a prior interest has to be created. So if I want to transfer any interest to the unborn child, so I have to transfer the property till birth of the child to somebody else, some living person. Rule against perpetuity, section 14. Till the unborn person comes to existence, there should be a transfer in favor of living person. The transfer should not postpone the vesting of property in the unborn person beyond attainment of his majority. Vested interest, section 19. In case transferor stipulates a condition that the transfer shall effect upon the happening of an event of must nature which is bound to occur in future, nature of interest of transferee is called vested interest. For example, A makes a gift to B of rupees 100 to be paid to him on death of C. Since death of C is certain, that means B gets a vested interest of rupees 100. Contingent interest, this vested interest, contingent interest is also very important. Theory, 1 mark theory or numerical or case study, small example based, case based theory question may come. In case transferor stipulates a condition, the transfer shall effect upon happening of an event which may or may not occur in future. So in case of vested interest, it was of full certainty. Happening of event was certain. However, in case of contingent interest, the event may or may not occur in future. So nature of interest enjoyed by transferee is called contingent interest. For example, a land is transferred to B if he pays rupees 500 to A. Then B's interest is contingent till he pays rupees 500 to A. Conditional transfer, section 25. If transfer of property is subject to fulfillment of certain conditions, it is called conditional transfer. The legal effect of the transfer may vary according to conditions. Following condition, if stipulated, are void, are not have no value, impossible to perform. For example, A leases out a farm to B on a condition that he shall walk 100 miles in an hour, or the said lease is void because he cannot walk 100 miles in an hour. Unlawful or forbidden by law, defeats the provisions of law. For example, A transfers rupees 500 to B as a condition that she shall murder C. That is, the transfer is void. If a condition is being put that you will kill somebody else and then I will pay only 500 rupees, then that transfer is not valid and it is void. Fraudulent involves any injury to a person or a property or opposed to public policy. For example, A gives rupees 500 to B on a condition that he shall marry to A's daughter C. At the date of transfer, C is dead. So I tell you that I will give you 100 rupees if you will marry my daughter. But my daughter has already been dead before today's date. So that transfer is void because my daughter is not there in existence. So I cannot put a condition to get her married because she has already died. Types of conditional transfer. There are basically three types of conditional transfer. Condition precedent, so in which conditions which are required to be complied with before transfer of the property. Here even substantial compliance is sufficient for transfer. For example, A transfers rupees 5,000 to B on a condition that he shall marry with the consent of C, D and E. If E dies and B marries with the consent of C and D, D is deemed to have fulfilled the condition. I told you that you will marry that girl after you will get married after taking permission from three persons, C, D, E. And if you will do that thing, I will give 5,000 rupees. But in case by the time you plan to marry, Mr. E died, he is no more. Then even if you take permission from C and D, that condition is deemed to be fulfilled. A transfers rupees 5,000 rupees to B on a condition that he shall marry with the consent of C, D and E. B marries without consent of C, D and E, but obtain their consent after the marriage. Then B has not fulfilled the condition. So in another case, I told you, you please get married after taking permission from C, D, E. You got married without intimating, without taking permission from any of them, C, D, E. But after getting married, you approached C, D, E to get their consent after the marriage. Then condition is not fulfilled. Condition subsequent. Conditions which are required to be complied with after transfer of the property. Thus, here interest of the transferee which is already been vested is affected by fulfillment of the condition. The subsequent condition must be complied strictly. The subsequent condition must be clear and must also be fulfilled clearly. Ignorance, illness or neglect cannot be taken as non-compliance of condition subsequent. Example, for example, A transfers farmland to B provided he shall go to England within 3 years. If B shall not go to England within the period of 3 years prescribed, after the date of transfer, his interest in the farm will cease. I gave a piece of land to you, subject to condition that you will go to England within 3 years. So if you do not comply with that condition and you do not go to England within time period of 3 years from the date of execution transfer date, the property will come back to me. A transfers rupees 500 to B to be paid to him on his attaining his majority or marrying, with the provision that if B dies as a minor or gets married without consent of C, then rupees 500 shall go to D. If B gets married only when 17, that is minor, and without consent of C, then rupees 500 shall be transferred to D. Third type of conditional transfer is collateral condition. So these are the conditions which are required to be compliant with simultaneously with the property. For example, A leases his property to B so long as B resides in the house of A. The condition is collateral. Here the transfer lease remains in operation till B complies with the condition. Next important act is section 35, the doctrine of election. When a person through an instrument, say agreement, proposes to transfer a property which is owned by someone else and also proposes to give some benefit to the owner of the property through the same instrument, the owner of the property must either accept the following of the two things or dissent from the two things. Thus, owner has to elect between accept or dissent. So, doctrine of election talks about I have to either accept it or reject it. So, transfer of property by transferor who is not owner of the property to the transferee, and granting of benefit offered by transferor to the property owner. In case of dissent given by the owner, the benefit shall go back to the transferor. In case before election is being done by the owner, transferor dies or it becomes incapable of making a fresh transfer, and if transfer is for consideration, representative of transferor pays the amount equal to the value of property that the transferor had attempted to be transferred to the disappointed transferee. This is a little bit complicated. Let us try to understand fairly with the help of some examples. So, for example, property worth rupees 800 is owned by C. A, by an instrument of gift, proposes to transfer the property to B and also offers benefit of rupees 1000 to C. So, property worth is 800 rupees owned by C. A wants to gift this property to B. A is not owner. Owner is C. So some third person A want to transfer this property to B and also offers a benefit of 1000 rupees to C. So if C elects to retain the property, he forfeits the gift of rupees 1000 rupees. So let me repeat. Property value is 800 rupees and it is owned by C. Now A, who is not owner of the property, has proposed to give this property to Mr. B. But since A is not owner of the property, so before giving it to B, he has to take this property from C. So against this, Mr. A offered 1000 rupees or a benefit of 1000 rupees to C. But C refused. C said, no, I don't want to sell my property against 1000 rupees. I want to retain my property. So in that case, the gift of 1000 rupees is forfeited. So C dissented. In the same case, above case, if A dies before election of C, the representative of A shall pay rupees 800 to B. This is a little bit complicated, difficult to understand, but from examination perspective, try to understand little bit about this concept. If any question may come, so you may be able to answer this question. So, in case A dies before the election of C, I repeat, so A had given an offer of 1000 rupees to C, but A dies before C gave his assent or dissent, yes or no. In that case, A's representative shall pay rupees 800 to B. Out of 1000 rupees which is offered to Mr. C, 800 will be given to, which is equal to property value to B. Limited power of transfer, section 38. In case there are multiple owners of a property, each owner has limited power to transfer the property. One or some, not all, owners can transfer the property under certain circumstances. He cannot transfer except under those certain circumstances. For example, husband of Hindu widow, say A, if is left with a field or a farm along with collateral heirs like brother, sister, mother, etc. If the earning from the field is insufficient for her maintenance, she can sell the property to B without consent of collateral heirs, in spite of having been limited power to transfer property. So this is an exception. Ideally, all owners should come and sell the property, but there is an exception in section 38 of TP Act. If I am a widow and I want to sell my farm because I want to sell my field or farm in which I have limited interest, along with brother, sister, mother of the deceased husband, but because earning for me are insufficient for my maintenance, so I can sell my property without taking permission from these collateral legal heirs. B, after satisfying himself by reasonable inquiry that the income of this property is insufficient for A's maintenance and the sale of the field is necessary, and acting in good faith, can buy the field from widow. That is A. Restrictive covenants. In case of registered instrument or agreement, stipulates some condition to either take or abstain from specific action by buyer. As per sale, for example, as per sale deed, if it is mentioned that the land can be used for residential purpose only, the buyer cannot use the land for any other purpose. It is restrictive covenant. Transfer of ostensible honor, Benami transaction. Who is ostensible owner? He is a person who has all the indications of ownership and looks like a owner of a property but is not a real owner. 1 mark theory question may come out of it. Benami transaction, it means property is being transferred to one person, however the consideration is being done by other person. I paid the money, but after making the payment I got this property transferred in the name of my Mali, in the name of my car driver. Benami Transaction Act 1988, the act states that the person in whose name the Benami property is held shall become the real owner of the Benami property. Burden of proof. In case of dispute over Benami properties, burden of proof lies on the person who claims that he is a real owner. Burden of proof we will discuss in law journal section, in most likely in next series, in next playlist. Burden of proof is like something, I have made some allegation on you, you are making some allegation on me. So I am claiming that I am real owner. You are saying that you are not real owner, this property is me. You are my car driver. So since I am claiming that I am the real owner and Benami Act has been applicable on this transaction, on this dispute, so that means the onus of proving my statement lies on me. I need to submit my documents to prove my ownership on that Benami property. Smelling a Benami transaction, following questions may be asked to test ostensible owner of the property. So as a valuer, while doing valuation of property, these questions may be asked to have a smell of Benami transaction out of the property. Source of purchase money. Who paid the price? Nature and possession after the purchase. Who had taken the possession? Motive for doing the Benami transaction. Why property was purchased in the name of the other person? You can ask this question to the owner of the property, is to understand whether he is the real owner or ostensible or Benami owner. Relationship between the parties, whether real owner and ostensible owner were related to each other or were strangers. Conduct of the party in dealing with the property. Who used to take care of and had control of the property. That is why possession is important. Custody of total document. Whether title document are in custody of the real owner or somebody else has taken in custody of him. Doctrine of estoppel. Section 43 of TP Act. It is a case of fraudulent transaction The transferor without having ownership can transfer the property to transferee of some other consideration for some consideration. So it is basically nothing but doing a fraudulent transaction. So if transfer without having ownership of a property gets transferred the property to somebody else for some consideration, it is called fraudulent transaction as per section 43 of IBBI Act. Later on, the transfer gets the ownership, and if the transferee has not rescinded, cancelled the contract, the transfer is bound to give the property to the transferee. For example, I don't own a property and I sold that property without ownership to you. But say after 2 days, 5 days, 1 month, after some time, I get ownership of that property. So I have to transfer that ownership subsequently to you, because earlier I was not owner, but still I sold that to you. But now I have got ownership, so I am bound to transfer that property to you. For example, a Hindu son A gets separated from his father and sells a property in the name of his father to C in good faith for some consideration. The transaction is fraudulent as of now. But if after death of the father, A becomes owner of the house and C has not cancelled the contract, then A is bound to give property to C. A property is there, for example, a property is there in name of my father. I am not owner of that house. I sold that house to you without having ownership of that house. So as of now, the transaction is fraudulent. But say you do not cancel the contract and you say, okay, let us go ahead. You don't know about the transaction, about the fraud happened with you under any circumstance. And after death of my father, the property get transferred to me. So the moment it get transferred to me, I am forced or bound to transfer that house in your name. Joint tenancy. We have already covered this topic in previous playlist also, just to repeat. It is also called joint ownership. All parties enjoy equal and undivided rights. So here rights are equal and undivided, always equal to the benefits of the property. But in case of death of one joint owner, his share get automatically transferred to the remaining surviving owners. So if there are four joint owners of a property, each person will get 25% share of the property. That is implied, even if it is not mentioned in the document. Number 1. Number 2, if any person out of these four owners get died, then the 25% will get divided among remaining three, and each owner will get a share of 33.33% out of the property. All owners have equal share in property and thus enjoy unity of titles. These all terms are very important. In case of joint tenancy, there is a concept of unity of titles. All owners have joint possession, thus they enjoy unity of possession. So in case of joint tenancy, there is an element of unity of title and unity of possession both. Tenancy in common. It is also called co-ownership or ownership in common. Here, shares of each owner may or may not be equal. In previous case, it was always equal. Here, it may or may not be equal, but is always undivided. So, in previous case, it was undivided and equal. Here, it is undivided, but ownership may be equal or may not be equal. This is first difference. And in case of death of one co-owner, his share will not get transferred to other surviving members. So, but his share will go to legal heirs of the deceased person. All owners have joint possession, and that is they enjoy unity of possession. So in previous case there was an element of unity of title and unity of possession. Both elements were there. Here in this case there is element of only unity of possession. There is no unity of title concept in this case. Doctrine of Lease pending. Lease means dispute and pending means pending disputes. It states that during pendency of a suit or inquiry or a litigation, a property cannot be transferred. Doctrine of past performance, section 53A. Is sale agreement is signed between buyer and seller of a property. Before signing the agreement, the buyer gives some advance to seller. Post signing the agreement, the buyer takes possession of the property. His right to perform is part of contract, that is ready to pay remaining amount as per contract terms. However, seller refuses to perform his part of contract, that is refuses to accept the money and seeks back possession of the property from the buyer. the section provides protection to the buyer. The protection is being provided on the basis of sale agreement duly signed and stamped even before execution of sale deed. So in case the sale agreement is being executed between buyer and seller of a property, right? And the buyer gives some advance to the seller. I am buyer, you are seller. I have given some advance to you. Post signing the agreement, I have taken possession of the property which you were proposed to sell me. But later on, you as a seller refuse to perform your duties as per contract. Or maybe I offered to pay you the remaining amount, but you refuse to take take that remaining amount, and you seek possession of the property from me. So this act provides protection to the buyer, this to me. So since I have signed an agreement to you, I have given advance to you, I am ready to pay you advance, and now you are refusing to accept the remaining amount. So based on that sale agreement, even before execution of sale deed, protection is available for me in PPA Act section 53A. So with this, we are done with general concepts of PPA Act. Now let us move to sale, section 54 to 57. Sale versus contract for a sale, section 54. So sale is a transfer of ownership in exchange for a price paid or promised to paid, or part paid or promise or part promised. So whether price is paid or promised that I will pay in future, or partly paid and the remaining part is being promised to be paid, that is sale. Contract for sale of an immovable property is a contract that a sale of such property shall take place on terms settled between the parties. So contract, it doesn't create any interest in the property or over the property. It is also called agreement to sale. Contract of sale is nothing but agreement to sale. Rights and liabilities of buyer and seller, section 55. In absence of a contract to the contrary, until unless something else is written in the contract, rights and liabilities of buyer and seller are under. If contract is silent or any contradictory statement is given in the contract, then it is a separate thing. But if these things are silent, then as per the TP Act, they are following rights and liabilities of buyer and seller. So rights of seller, the seller is entitled to take rent and profit from property till ownership gets transferred. So I have sold the property to you. Till the actual transfer happens, all rent and profit from the property will come to me. If something else has been agreed between us in the contract. In case ownership get transferred to buyer before making full payment, seller is entitled to receive remaining payment along with overdue interest if any. So in case I have already transferred this property to you and you have not made me the full payment, then the remaining payment along with any overdue interest from due date, if any, has to be paid by you as a buyer to me as seller. So these are the liabilities of seller. The seller is bound to disclose any material defect in the property to buyer. If I am selling a property to you and I am aware of any defect in my property, it is expected that I should tell that defect to you. To produce buyer on his request all documents of the property for examination. If I am selling a property to you, all documents, title chain document, if you ask from me, I should provide you. Whatever information I have and whatever questions you ask to me about the property, I should answer all your questions to the best of my knowledge about the property. On receipt of the payment from you, I should execute a proper sale deed in favor of you at a suitable time and place as per mutually agreed. Between dates of contract and sale deed, as a seller, I should properly take care of the property and its title documents as in normal course. To give possession of the property to buyer or his representative. So since you have agreed, I have signed an agreement with you to sell this property to you, I should give a peaceful possession of the property to you or to your representative. And it is, as a seller, it is my responsibility to clear all public charges, taxes, and encumbrances till the date of the sale, till the transfer gets happened. So the exception is that if the property is under mortgage and with encumbrance, the property is being transferred, both buyer and seller have agreed to get it transferred under encumbrance, then it is an exception. Otherwise, all encumbrances, taxes, property taxes, electricity bill, sewage bill, water dues, till the date of the transfer should be cleared by the existing or previous seller. Liability of buyer. The buyer is bound to disclose any fact of which buyer is aware, and he has a reason to believe that the seller is unaware of, and which materially increase the value of such property. For example, I am going to buy a property from you, right? And I have some confidential information that there is an airport which is coming near to this land, and the price of the property is going to be rise by 30-40% by tomorrow or within near future, that I am expecting, and I have solid reason that you are not aware of this fact, because of which you are going to sell this property at a lower rate to me. So it is my duty as a buyer to disclose that information to you, that a nearby airport is likely to come. Last night government has approved, and tomorrow news will come in the market. So I should tell you. The buyer has a liability to pay full consideration amount to the seller as agreed. Whatever amount has been agreed, I have to pay to you as a buyer. After transfer of ownership to the buyer, to bear any loss arising from the destruction, injury, decrease in value of the property not caused by the seller. So if I have purchased a property from you, after it get transferred to me, whatever loss will happen to the property, say earthquake will come or some damage will happen, if that loss or damage is not because of the seller, then as a buyer I am responsible. I will take care of all the losses. All public charges issued with the property with effect from transfer of ownership. So the moment the property get transferred, all charges, public charges related to the property shall be borne by the new buyer. So there are certain rights which buyer enjoy as well. The buyer is entitled to enjoy benefits of any improvement or increase in value of the property and rents from the property after transfer of ownership in his name. So the moment property get transfers in my name as a buyer, any increase in value of the property or an increase in rent of the property will be mine. Seller cannot claim on that unless he has improperly declined to accept delivery of the property. He can claim back his payment with interest and other cost, if any, from the seller in case of non-service of contract of sale. So now let us move to mortgages and charges, section 58 to 104. Section 58 of TP Act talks about definitions. What is mortgage? Mortgage is transfer of interest in a specific movable property to secure a debt, loan, both existing and future, or performance of an engagement which may give rise to a pecuniary liability. What does that mean? Relating to or consisting of money. So mortgagor is transferor, owner of the property. There is mortgagor. So these terminologies will be repeated many times. So we should remember who is mortgagor, mortgagee money, mortgage deed. So mortgagee is transferee, that is bank lender. Transferor owner is mortgagor. Transferee bank lender financial institute HFC, the person the institute or company or person who lends the money, lender is mortgagee. Mortgage money, amount of debt which has been secured against the mortgage of the property, and mortgage deed is the instrument, if any, by which the transfer is equipped. Mortgage has been created basically. So these are the 6 type of mortgages as per section 58. Simple mortgage, mortgage by conditional sale, usufructuary mortgage, English mortgage, mortgage by title deposit or title deeds. This is most common within India among bank. Anomalous mortgage. So let us understand all these 6 type of mortgages in subsequent slides. Simple mortgage is mortgagor without giving possession of the property binds himself to pay the mortgage money, and also agrees that in case he fails to do so, the mortgagee shall have right to sell the property to recover his dues. Minimum characteristic of simple mortgage is that the mortgagee has no right to liquidate the property without permission of court. So mortgagee, the bank, cannot sell the property without permission of court in case of simple mortgage. However, mortgagee, the bank, gets the right to sell the property to recover his dues, but possession remains with the mortgager. So these three important points are there in case of simple mortgage. Mortgage by conditional sale. Here the mortgager ostensibly sells the property to mortgagee on condition that if mortgager defaults in payment of loan on due date, then the sale shall become absolute. So basically here the mortgager actually sells kind of fictitious sale is being done in the name of mortgagee or the lender, and the mortgager defaults. If mortgager doesn't pay the loan, then mortgagee can sell the property and the sale becomes absolute. It's a conditional sale kind of thing. If such payment being made, the sale become void. If mortgager pays the loan, then this sale becomes void. Or if full loan is repaid, the buyer shall transfer back the property to mortgager. Clear? So if total loan amount is paid, then as per this conditional sale, the bank or lender or mortgager will transfer back the property to the original owner or mortgager. Usufructory mortgage. It has following features. Possession of the property is given to the mortgagee. Here the mortgagee, the lender, gets the possession of the property. Mortgagee gets the rent and profit in lieu of interest or principal, or both. Maybe both. So basically I have taken loan from the bank, so I'll give possession of my property to the bank, and bank will take care of the property. Bank will take rent from the property. Whatever income will come out of property, against that income bank will set off its interest or principal or both. So no, there is no personal liability of me towards the as a mortgager. So only my property is mortgage. I don't have any personal liability. The mortgagee cannot foreclose or sue for sale, because the property has already been transferred is in possession of the bank. So bank cannot foreclose or sue me for sale of the property. English mortgage. Here mortgager binds himself personally. So I am owner, I have mortgaged my property, so I bind myself personally to repay the loan on a certain day. The property get transferred absolute to the mortgagee. However, I transfer my property absolutely. Earlier it was conditional, now it is absolutely transferred to the bank. And in spite of absolute transfer, the mortgagee will return the property to seller upon full payment of the loan. So though I have fully transferred the property to the bank, but still bank cannot sell that property till the time I will continue paying my EMI, and after I make full payment of the loan to the bank, then bank will again transfer it back to in the name of me. Mortgage by deposit of title deeds. It is also called equitable mortgage. So it has following essential requirements. This is very important. 1 mark theory question may come. So there must be a debt. If for creation of equitable mortgage, three conditions are there. There should be a debt, loan amount between lender and borrower. There should be deposit of title deeds with lender. Even mere deposit without creation of any document is adequate for creation of equitable mortgage. However, to be on safer side, banks do create ABC for creation of mortgage of title deed, mortgage by deposit title deeds. So deposit of title deed should be there, and title deed to be deposited with an intention as security for debt. Say I visited the branch and I somehow by mistake left my property sale deed on table of branch manager. I did not take any loan, and I had no intention to give my property paper against as security for any loan. Then it is not considered to be mortgage. Even if I had taken a personal loan, unsecured clean loan, and I took my sale deed to the branch to deposit those sale deed to keep those sale deed into locker of the same branch. But by mistake I kept the sold deed on table of branch manager. So bank cannot say that you deposited the sale deeds. So there has to be debt, there has to be deposit of title deed with the lender, and there has to be intention also to deposit the title deed with the lender against to secure the debt. Anomalous mortgage, any other mortgage except above 5 types of mortgages within which are defined within meaning of section 58 of TP Act is called anomalous mortgage. Mortgage by assurances, section 59 of TP Act. In case principal debt money is more than or equal to 100 rupees, mortgage can be effected by a registered instrument signed by mortgage and attested by at least 2 witnesses. So if loan amount is 100 rupees or more, then mortgage can be created with the help of a registered instrument only. And it has to be signed by mortgagor owner. And there must be 2 witnesses for completion of the mortgage. If principal loan amount is less than 100 rupees, except in case of simple mortgage, mortgage can be created or effected merely by delivery of property. Here there is no mandatory requirement of getting the registered instrument signed by mortgagor. So this is as per the TP Act. So let us see what are the rights of mortgagors. First right is as per section 60 is right to redeem. Mortgagor is owner of the property. The right to take back the property once loan is repaid. It is an important statutory right of mortgagor owner of the property. Once mortgage is always a mortgage. So once I have given a mortgage, it remains mortgage till closure of entire loan account. In mortgage agreement, if any condition prevents the mortgagor in getting back his property after repayment of the debt, such condition shall be void. If say by mistake or by intentionally and unintentionally, lender stipulates a condition that after payment of the debt, the property will remain with me, that condition is void ab initio. Right to partial redemption is also available. If mortgagee himself acquired the property, general rule for partial redemption is not permitted. For example, A and B and C are joint owners of a property. For example, the property is mortgaged for debt of say 30,000 rupees. Later, for example, A by making a payment of 10,000 rupees cannot redeem separately. For example, you and me are two friends basically. We have taken a loan of 20,000 rupees from a bank. So we both have 50% share of that loan. So tomorrow I cannot say that I will pay my 10,000 rupees and you please leave my share. That is not possible. Rights of mortgagor. Obligation to transfer to third party instead of transferring it to mortgagor. Section 60A. The purpose of this right is to help the mortgagor to pay off the mortgagee by taking a loan from third person on the same person. It is a kind of balance transfer, takeover of the loan. So if I have taken a loan from a bank, I can transfer till during mortgage of that loan, mortgage of the property with my existing lender, say SBI. I want to transfer it to Axis Bank, for example. So now this act allows me to transfer my loan, home loan, from existing bank to new bank, even if the property is being mortgaged with my existing bank. Section 60A gives this right to the mortgagor. Right to inspection and production document. Section 60B. Mortgagor can ask mortgagee to have inspection of the property and ask for copies of title document at the cost to be borne by mortgagor. So if I have given my property under mortgage to a bank, I can ask my bank to please allow me inspection of the property if it is in possession of the bank, and if bank has taken loan documents with them, so I can anytime ask photocopies of those sold deeds from the bank, but the cost of photocopy and recovering those documents has to be borne by me as a owner of mortgagor. Right to recover possession. This is also another right of mortgagor. Right to accession. Section 63. Here accession means any addition to the property and can be of two types: artificial accession and natural accession. When the mortgagor made some efforts leading to increase in land value. So artificial accession means as a mortgagor, as an owner, I have constructed one extra room in the property. So that is artificial accession. If natural accession is if value of land increases without any human effort because of change in climate or some other things. the property value has increased. In case a cession is on account of efforts of mortgagee bank, the mortgager has to reimburse the cost incurred to do so by the mortgagee in order to enjoy the benefit of accession if such accession is not separable from the property. Say my bank had taken possession of the property, my bank had constructed one room in that, and that room cannot be separated from the property after loan is being repaid, then I have to pay reasonable cost to the bank for that extra room if I want to enjoy that room. Right to improvement, section 63A. If mortgaged property gets improved while in possession of mortgagee means lender, the mortgager is entitled for such improvement even without paying for such improvement to the mortgagee unless improvement made by the mortgagee were to protect the property or with prior permission of the mortgager. The second circumstance could be improvement were made by a mortgagee with the permission of public authority. Right to renewal of mortgage lease. So if I am owner of a property and I have given the property under mortgage to a bank, and during mortgage of the property the lease get expired, so I have a right to get that lease renewed. So next are the duties of mortgagors. Section 66 states about duty to avoid waste. So mortgagor, owner, should not do any act leading to reduction in value of the property. Waste is of two types: permissive waste, active waste. So if I have given a property on mortgage to a bank, so I should take care of that property as in normal course. So permissive waste, a mortgagor who is in possession of the property, mortgage property, is not liable to the mortgagee for any minor waste. So any small damage, say I want to uh, uh, put some, I want to hit some nail into wall and just to hang a wall clock. I want to make a hole in my wall just to hang some drawing or picture or portrait. So that is a permissive waste. Mortgagee cannot ask any question to me. But when an act leads to major loss in value of the property, the mortgagor is liable to the mortgagee. So I cannot demolish the structure of a building which is already mortgaged with the bank. Duty to indemnify for defective title. In case of third party claim over the title of the property mortgaged, mortgagor need to compensate mortgagee for the expenses incurred by mortgagee for protecting title of the property. Say I have mortgaged one property to the bank and took housing loan. After some time, some other person comes into picture and he claims his ownership on that property. Then to protect title of the property, bank spends some money. So as an owner, I have to reimburse the bank for that money which bank spent to protect my title on the property. Duty to compensate mortgagee. In case the property is in possession of mortgagee and mortgagee pays the taxes and other local charges, then mortgagor should reimburse all the charges. So if possession is given to the mortgagee, the bank, then bank will pay the property tax, water bill, whatever statutory dues are there, and mortgagor as an owner, I have to pay those expenses to the mortgagee. In case the possession is with the mortgagor, all such taxes, other public expenses are to be paid with the mortgagor. So if I have taken housing loan, the house is in my possession as an owner, then I have to pay all taxes and other public expenses pertaining to the property. Duty to direct rent to mortgagee. In case I have taken a loan on a property and I have given the property on rent, then entire rent should get transferred to the account of the mortgagee, the bank. At least it should be in knowledge of the bank. If bank want to put that amount into loan account, then it is fair enough. No issues. Rights of mortgagee. Right to foreclosure, 67, section 67 of TP Act. In case principal amount has become due and not paid by the mortgagor, the mortgagee can obtain a decree of foreclosure from the court to recover his outstanding money. Mortgagee can exercise this right before mortgager owner obtains decree of redemption from the property from the court. The suit filed by the mortgagee to obtain the decree of foreclosure is called suit for foreclosure. Right to sue for mortgage money. The mortgagee has the right to sue the mortgager for mortgage money in following cases: where the mortgager binds himself to repay the same, where the mortgagee is deprived of whole or part of the property on account of wrongful act of by the mortgager, in case possession of property is sought by the mortgagee but mortgager fails to do so. Right to exercise power of sale. The mortgagee has right to sell the property without intervention of court if due debt is not paid by mortgager and after giving him proper notice period. So lender can sell my property without giving notice and without help of court as per section 69 of the TP Act if my loan amount is due and after giving proper notice to me as a borrower. Right to have receiver appointed. The mortgagee can appoint a receiver on his behalf to receive income of the mortgage property. So as a lender, I can appoint a receiver to collect rent from the property. Right to accession, section 70 of TP Act. Mortgagee gets automatic charge of the accession, if any, on the property after mortgage. So after creation of mortgage, any accession to the property gets vested automatically with the lender. For example, if mortgager constructs a house in a plot already mortgaged, the mortgagee gets automatic charge on the house. Very important. Say I have purchased a plot, or I mortgage a single story building with a mortgager with the bank and took a housing loan. But subsequently, after 1 or 2 years, after some time, I constructed another floor on the building. So the bank did not fund me for second floor, and when I mortgaged the property, second floor was not constructed, and I have constructed second floor my own sources. Even then, the bank will get automatically charged on second floor. Right to the benefit of renewed lease. In case the mortgage of leased property, if the lease deed gets renewed, the mortgagee is entitled to get the benefit of the renewed lease. So like I have taken a loan of 20 years and the remaining lease period is 10 years, then mortgager has the right to get it renewed, but mortgagee also has a right to get the renewed lease under its possession. Rights to produce of renewed revenue sale. In case of sale of a mortgage property on account of non-payment of taxes or other public charges, surpluses if any, from the sale proceeds, after deducting taxes and other public charges etc., shall be taken by mortgagee and adjusted with that. Say, I have mortgaged property. Because of non-payment of property tax, the bank receives a notice from property tax department for payment of taxes. The borrower is not clearing the dues. Now bank has no option but to sell the property to clear off the statutory dues. So in order to clear the dues, the bank has to sell the property. So dues are of 10 rupees, property is of 100 rupees, loan amount is of 60 rupees. So bank will sell the property, first pay the dues, then out of remaining 90 rupees, bank will clear its dues of 60 rupees. Bank has right to clear its dues also, debt. So these are the liabilities of mortgagee. When property is in possession of mortgagee, it has following liabilities, duties. Property may not be damaged. There should not be any alteration is allowed in the property. The property must be insured. Important point. Property must be kept secured. Rent of the property must be collected. Government revenue must be paid timely. Property must be kept clear from all dues. So these are the duties and responsibility of mortgagee if property is being held under possession of the mortgagee. So next part of TP Act is lease. It is covered under section 105 to 117. Section 105 of TP Act talks about various definitions related to lease of property. A lease of immovable property is a transfer of a right to enjoy the property for a certain period or perpetuity. It could be express or implied against consideration of a price paid or promised to be paid, money, a share of crop, a service, or any other thing of value. Lesser, he is owner of land or land plus building who gives away possession of his property on rent on certain terms and conditions. The sum of the freehold rights are passed on to the land user, that is lessee. Then lessee, he is tenant of the property on terms as mentioned in lease agreement. Sublessee, if lease agreement allows lessee to sublet, the subtenant is called sublessee and main lessor is called head lessor. Premium is price paid or promised. It is one-time payment to be obtained to obtain the lease. Rent is nothing but money, share, service, or any other thing to be so rendered, that is recurring payment. We have already covered this lease part in income approach to valuation in detail. So you can have further details of type of lease and then rents, outgoings, and numericals, case studies after going through that playlist which is on income approach to valuation. Please look into the description box below. So there are different kinds of lease as per TP Act. First is perpetual lease. Second is tenancy at will or estate at will. So perpetual lease is, this lease has ongoing tenure over stated period. The lease is normally issued for a specific purpose, for example agriculture or commercial. So normally 99 years, 999 years of lease are called to perpetual lease. But from numerical perspective, any lease more than 50, 60, 70 years of period is presumed to be perpetual lease. Tenancy at will or estate at will. Here no lease or written agreement is being signed between tenant and landlord. So there is no explicit agreement signed between tenant and landlord. Only there is a verbal contract, and which can be terminated by either tenant or landlord at any time. It exists without a contract or lease and usually doesn't specify length of a tenant's duration or the exchange of payment. Next type of lease is tenancy at sufferance. It is a situation where the tenant continue to occupy the property even after expiry of lease and without consent of the landlord. Please note down the statement which is given under underline. The tenant in this situation is called holdover tenant. So 1 mark theory question may come, who is holdover tenant? So if the property is being occupied by tenant after expiry of lease and without consent of landlord, then the tenant is called as holdover tenant. The tenant is liable to pay monthly rent at existing rate and terms which the landlord may accept without admitting the legality of the occupancy. If the tenant doesn't leave even after a notice of quit, move out, he is subject to lawsuit for unlawful detainer. Tenancy by holding over. A holdover tenant is one who continues to occupy the property even expiry of lease and landlord continues to accept rent payments. Thus holdover tenant can continue to legally occupy the property, and law determines the length of the holdover tenant's new rental terms. Periodic lease, it is a lease for from year to year or month to month. Lease for fixed period, here period of lease is fixed. Lease for life, it is a lease for lifetime of the lessee. Please note down lifetime of the lessee, not lesser. Under this type of lease, period of lease is fixed as equal to the remaining lifespan of the lessee tenant. The lease period will mature on date of death of the lessee. Thus, on death of the lessee, the lease comes to an end. Lease is coterminous with the life of lessee. Please note down this statement. 1 mark theory question may come. This type of lease creating life interest is not common in India. Next is rights and liabilities of lessor and lessee, section 108 of TP Act. Liabilities of lessor. Duty to disclose. Lessor is bound to disclose any material defect in the property which lessee is not aware of. So, landlord should disclose all material defects of the property, and such defect after affect right of enjoyment by lessee. Duty to give possession on lessee's request. Lessor is bound to give possession of the property to the lessee. Covenant for quiet enjoyment. If lessee pays rent on time and performs the contract terms, lessee may hold the property and enjoy the property during the lease period without intervention of the lessor. So if tenant is paying rent timely, all terms and conditions are being complied with, then landlord should allow tenant to enjoy, lessee to enjoy the property without any intervention. Rights of lessee. Right to accretion. Any addition or accession to the property during lease period shall deem to be comprised in the original lease. The addition may be natural or at expense of a lessee. For example, tree planted by tenant. I have taken a property on rent. I have planted a tree of mango tree. So whatever mangoes will come out of the tree will be enjoyed by me as tenant. However, the lessee cannot have title to such addition after expiry of the lease period. Once the lease period is over, I cannot have claim over mangoes of the tree since it was planted by me. Right to void lease. In case of destruction of the property for no fault of lessee, the lessee has an option to make the lease void. In case of advance lease rent paid by the lessee has right to recover the proportionate rent from unexpired lease period from the lessor. For example, I have taken a property on lease and the property gets demolished because of earthquake. Then I may stop paying rent to my lessor. And if I have made a advance payment of rent to the lessor, I can claim it back, proportionate rent. Right to charge for repair. If lease deed is silent on maintenance cost of the property, then lessor is responsible for maintenance of the property. If after notice of reasonable time, landlord or lessor doesn't repair it, the tenant, lessee, has right to get it repaired and deduct the repair cost from the lease rent. If lease deed stipulate that maintenance is to be borne by lessee, then lessor is not responsible for that. Maintenance is normally being taken care by landlord until unless some contrary clause is being mentioned in the lease deed. Right to make payments. If lessor neglects to make any payment which he is bound to make, the lessee can make such payment pertaining to the property and has right to deduct it from the rent or recover it from lessor. For example, property tax payment. The lessor has to pay. If some contradiction is not mentioned in the lease deed, then tenant can pay the property tax and deduct it from the monthly rent. Right to remove fixtures. During lease period, the lessee has the right to remove things which he attached to the earth. However, he has to leave the property in the state in which he received it. So after taking property in my possession as a tenant, if I have installed some machinery on that land, I can take back that land after I vacate the property. However, there should not be any damage to the property. So whatever form, whatever shape the property I had taken, same way I have to return it back to the owner. Right to have benefits of crop. When a lease is of uncertain duration and the interest of lessee is determined otherwise than his fault, determined means closed, terminated, the lessee is entitled to the benefit of all crops growing, planted or sown by the lessee in the property. So if I have taken a land on lease for undefined period, I have grown a crop of say wheat, and till cultivation of that crop, the lease gets terminated because of no fault of me, then I have all rights on that crop. Thus, even after expiry of the lease period, the lessee and his servant are given free right to enter upon the property to gather and carry the crops. The lessee cannot claim to retain possession until crops are cut. Rights to assign his interest. In absence of any contract to the contrary, the lessee can transfer his interest partly or wholly in the property by way of sublease or mortgage. Rights of liabilities of lessee. Duty to disclose material facts, materially increasing the value of property. So lessee is bound to inform the lessor, landlord, about any fact which may increase value of the property, and lessor is unaware of the fact. So where lessee fails to disclose the fact and lessor suffers loss thereby, lessor can sue, landlord can sue the tenant for compensation. Duty to pay rent. Lessee has a duty to pay premium or rent to the lessor at proper time and place. In case the lessee fails to do so, lessor can either file a suit for arrears of rent or he can start ejectment proceedings on ground of non-payment. Duty to maintain the property. On expiry of the lease, the lessee is bound to restore the property in as good condition as it was when he was put into possession. So before whatever condition I had taken the property as a tenant, it is my duty to give back that property to the landlord in same condition. Lessee is bound to allow lessor and his agents to enter upon the property and inspect its condition. So I cannot stop my landlord or his agents to enter in the property, have an inspection of the property. Only changes caused by reasonable wear and tear or irresistible forces are allowed under this clause. And in any normal course, like I have, hang a, I have punch a nail in wall to hang my wall clock. That is normal wear and tear. That is allowed, but I cannot damage that property. Duty to give notice. If lessee gets to know that any person has initiated any proceeding to recover whole or part of the property or has encroached upon it, the lessee must bring this fact to the knowledge of the lessor. So if I am residing in a property and it comes to my knowledge somebody is trying to encroach or claim his right fully or partially on the property, so I should immediately intimate my landlord, lessor. Duty to use property in a reasonable way. The lessee should use the property as a person of ordinary prudence, as if it was of his own. He must not cut trees or sell timber or damage building belonging to the lessor. So if before taking a house, a mango tree was there in that house, so I'm not supposed to cut that mango tree during my possession as a tenant. Duty not to erect permanent structure. The lessee cannot erect any permanent structure on the property without consent of the lessor. I have taken a ground floor building on rent. I cannot construct another room on that building without permission of the lessor, except permanent structure for agriculture purpose. There is an exception. Temporary structure can be converted, and those are required to be removed after I will vacate the house depending on terms and conditions of the lease. Duty to restore possession. On determination, that is expiry or termination of the lease, the lessee is bound to give possession of the property to lessor. If lessee doesn't do so, he becomes liable to pay damages as well as mesne profit to the lessor. Please note down what is mesne profit. It means profit of an estate received by a tenant in wrongful possession. The rule is known as rule in Henderson versus Square. So 1 mark theory question may come out of mesne profit or out of this rule also. Determination or termination of lease. Lease of immovable property determines or expire in following circumstances if the fixed lease period gets over. If the interest of lessor in the property terminates, the landlord interest gets terminated. Surrender. There can be implied surrender if lessor grants a new lease to a third person with the assent of the lessee under existing lease, who delivers the possession to such person, or where the lessee directs his subtenant to pay the rent directly to the lessor. So I have sold the property to somebody else and I instruct my tenant to pay that rent to somebody else. If that condition is there, then the lease can continue, otherwise it gets closed, it gets surrendered. It is assumed to be by forfeiture. Forfeiture means the lease can be terminated and property revert to the freeholder. This could arise if leaseholder breaches terms of the lease on expiration of notice to determine the lease or to quit. Now, important section is lease versus license. So, lease is a transfer of an interest in a specific immovable property, while license is a bare permission without any transfer of interest. A lease creates an interest in favor of lessee with respect to property, but license doesn't create such interest. A lease is both transferable and heritable. Sublease can be created, and on death of tenant, the tenancy can be inherited by his legal heirs, whereas license is neither transferable nor heritable. License comes to an end if either of grantor or guarantee dies. Lease doesn't come to an end on either of death of grantor or guarantee. So basically, because of these benefits of license, are majority of landlords give their property to house landlords give their house on rent on license instead of lease. Just because of benefits of license over lease, right? So these are the few comparative points between lease and license. So few more points are there on next slide. The license can be withdrawn at any time at a pleasure of grantor. Who was given the license, the owner, landlord, can withdraw the license. But the lease can come to an end only in accordance with the terms of the lease contract. The lease remains unaffected even if the property is sold to third party. So I have sold the property to third person, the lease will continue. In case of license, the property is sold to third person, it comes to an end immediately. The lessee in possession of the property is entitled to any improvement or accession made to the property, while a licensee is not. So these are the important comparative point between license and lease. 1 mark theory question may come out of these two slides. Next is exchange. Exchange is nothing, and it happens when two persons mutually transfer ownership of two things and neither of two things is money. The transfer is called exchange. So if two things are getting exchanged and neither of these two things which are being exchanged is money, the transfer is called exchange. So one definition, please remember, it may come. Gifts. It is a voluntary transfer of movable and immovable property without consideration by one person who gives the gift is called donor to another person who accepts the gift is called donee, and also accepted by donee. So it is a voluntary transfer. It can be movable or immovable property, and there should not be any consideration, and it should be given by donor to donee, and it also should be accepted by donee. Acceptance should also be there for creating a gift. Acceptance when to be made? Acceptance of gift by donee must be made during lifetime of the donor. I have given gift to you till I am alive, you should accept it. While he is still capable of giving, and I should not be insane. I should not be liquid. I should be capable of giving that gift. If donor dies before acceptance, the gift is void. I have given a gift to you, I die before you accept it, the gift becomes void. How to transfer the gift? Section 123. In case of movable properties, the transfer may be effected either by a registered instrument with two witnesses or mere by delivery. So in case of movable property, transfer may effect by registered instrument with two witnesses and or by delivery. But in case of immovable properties, the transfer must be effected by registered instrument attested by two witnesses only. On reverse gift, it is a gift that is subject to some conditions. It is also called conditional gift. These conditions are imposed on the donee. The donee is at liberty to accept it or not. I have given you gift subject to certain condition. So it is your wish to accept those conditions or not. That is, it is a gift combined with some obligations also. Universal donee. Universal donee is one whom the donor gives his whole property, and consequently donee becomes liable for all debts due to donor at the time of the gift to the extent of property and comprise of the gift. So basically, I have given all my properties to you. So there were certain loans on those properties. So those loans will also get transferred to you. So in that, if you accept that gift, so property with liabilities, asset with liabilities, both you accept together, then you are called universal donee. Gift of existing and future property. A gift comprising of both existing and future property is void as to the latter. So future property cannot be gifted. Gift to several of whom one doesn't accept. A gift of thing to two or more donees of whom one doesn't accept it. Say I have given a gift to two or more persons, out of which one person doesn't accept the gift, but one person accepted, one person doesn't accept, is void to the interest as to the interest which he would have taken had he accepted. So he is void to the extent of the person who would have accepted, donee would have accepted. And last section of the TP Act is actionable claims, section 132, 132, 137. It is a claim to any debt except secured by mortgage of immovable property or pledge or hypothecation of movable property, or to any beneficial interest in movable property which is not in possession of the claimant. So please note down this definition. For example, A borrowed some money from B. B transferred the debt to C without intimation to E. I had taken a loan from A, bank A. The bank A sold my loan account to bank B without intimation to me. Now if B demands, let it be simple, I am A and I took a loan from bank B, and that bank B transfers my loan to bank C. Now if B demands money from A, that is my existing bank demands money from me, and I pay my loan to my bank B, the payment is valid and C cannot sue A for the debt. So since B had sold that account to some other bank C and it was not intimated to me, so I was under impression that my bank is B. My bank is B. So bank asked money from me. I paid that money to B. So now C cannot sue me for the loan amount. Thus, C, while taking or buying debt from B, should ensure that B should intimate A that the debt has been transferred to C. So that means the learning is that the C bank, the other bank, should ensure that the selling bank should intimate the borrower that his loan account has been transferred from B to C bank. Now B bank has no right over the loan account and C will directly take money from the C bank. Another example, a debenture is fraudulently issued in the name of public company, say to X. If X sells and transfers the debenture to Y, who has no notice of fraud, the debenture is invalid in the hands of Y. So that was a quite lengthy session, but that's all in today's session about TP Act. So before I'm going to tell you what we are going to have in next session, upcoming sessions in current playlist of laws related to real estate, I would request you to please subscribe to this channel and click on bell icon so that you will be made notified about upcoming session. So in upcoming sessions we are going to cover Rent Control Acts, Right of Way, Section 52, RERA, and we will also have a quick walkthrough of laws of inheritance succession. So we'll try to cover these remaining topics into 2 upcoming sessions. Thank you.